Good evening, everyone, and welcome to Scope Parent Training Workshop Series. I'm Ashwini, and I'm joined by my colleague Shitija as well as Sabuha on this call. Before we dive in, here's an intro to Scope. We are an initiative of SKN Foundation, supporting South Asian families of children with disability through education, advocacy, empowerment. These workshops are providing general guidance or information. So please consider check in with your own providers for advice specific to your family. Tonight, workshop demystifies the complex process of obtaining guardianship for children with disability. We hope this empowers our family with the knowledge they need to make informed decisions and plan for the future with confidence. So meet our speaker Rekha V. Rao, founder of the Rao Legal Group LLC. She specializes in estate planning, Medicaid, wealth preservation, and disability benefits. Licensed in New Jersey and New York, she actively serves on nonprofit board supporting community and disability initiatives. Before we dive in, a few quick reminders for our audience. Please mute your mic until the Q&A. We are recording the session, and we'll also be taking a few pictures for our social media. So if you have any questions, please don't hesitate to reach out to us. You are welcome to share your comments and feedback. And in fact, our speaker will be doing a few questions, and we would like your participation by your interaction through the chat. And don't forget to participate in our polls also. It helps us to improve our workshops. With all that, thank you all for joining us tonight on this call, and a warm welcome to our speaker Rekha for coming back to us again and to help our families learn about guardianship. Thank you.
Thank you, Ashwini. Thank you so much. It's good to be back. Humbled by the fact that I've been called back a second time, so this is really nice. And I see some familiar names. So hi, everybody who I've known from before. And it's good to see you here. I can't see some of your faces. It would be great if you could turn on your video so I can see you. It'll be a lot more personal as we go along through the presentation, but I understand it is 7 o'clock in the evening. You're probably getting dinner or taking care of the kids. But I wanted to thank the SKN group, the organization, to invite me here today. We've been talking about this for a while now, Ashwini, and so this is nice that it's actually come to fruition. I know that for me, the topic was something that Ashwini requested because apparently a lot of you parents are interested in hearing about guardianship. So let me just go ahead and share my screen. All right, so can Ashwini, thumbs up if you can see my screen? Okay, great. So this is, what I wanted to do is just sort of first give a brief introduction of our team, our firm. And the topics you see on the screen are actually things that we heard that you wanted to know about. So differences between the conservatorship and guardianships, why and when you might need to consider guardianships. I'll go through some of the legal paperwork that you need for that, and then talk about some alternatives to guardianships, etc. So give me 1 second while I just fix my screen a little bit. I do want to be able to see everybody if I can. Okay, great. So as far as our team goes, we are 7 members strong. I have to say that we got our first male addition earlier this year. So Rohan Subarna joined us. He's coming from family law, and he is an associate attorney. He's been working the family law space for about 3 years now, and he joined our team in January because he wanted to know more about estate planning. And so we're very excited because he's our first male addition to the team. So I say we are small but mighty. And I have to say that we are all, I think every single one of us here embody the tagline of our team, which is where strategic planning meets compassion. So in my next slide, I will be putting on a video. So bear with me for a minute and indulge me while I have you listen to something which probably you will say, why is she sharing this video? Does it make any sense? But I want you to reserve your judgments until later because at the end, I'm going to ask you if it makes any sense. So take a listen. If I can move it.
Introducing the Emergency Fire Blanket from Prepared Hero. The Emergency Fire Blanket is a lightweight, portable, easy-to-use tool to put out fires safely and effectively. There's less mess than there is with a fire extinguisher. It can withstand temperatures of over 1,000 degrees, and it can put out several different types of fires. Pull it out of the pouch and toss it on a fire. It's better to have it and not need it than it is to need it and not have it. Get your peace of mind today with the Emergency Fire Blanket by Prepared Hero.
Okay, as I said, I am not going to take any questions at this moment, but I wanted to see if you can find a link towards the end. So let's begin with the actual meat and bones of this presentation, right? So the thing that you guys wanted to know about was what's the difference between a guardianship and a conservatorship, and how different is that? It's interesting because in New Jersey, and remember, this is all state law driven, but in New Jersey, a conservatorship is actually voluntary. And so you cannot have an incapacitated person opt for a conservator to be appointed on their behalf. The court may have the right to appoint an attorney to just kind of check on their welfare, but in terms of them accepting this conservator to be appointed for them, it's really a choice that they make. And typically you will see this in a elderly person situation where they are maybe struggling with finances, paying bills, filing their taxes, and a family member will put forth an application to say they really need some help. And the conservatee actually says, okay, I will have this person as my conservator. So that is very different from a guardianship. A guardianship is, as you can see on the slide, there's different ways to get a guardianship process established. One is guardianship of the person. That means somebody has to be looking out for the well-being of the person, the healthcare, speaking to the doctors, taking care of them physically at home, which is most parents of children who are having some sort of disability or special needs. They are taking care of the person of that individual. So it's the guardianship of the person. The second would be the guardianship of the estate, where some people may say, just like a conservatorship, except here it's involuntary, right? They have to be appointed to be in charge of the assets of the incapacitated person. And most often you'll see someone being the guardianship of the person and the estate. Now, I say most often because I'm typically talking about an adult incapacitated person who has assets. But for many of you who are on this call, you probably have children who have no assets. And in that case, it's really the guardianship of the estate that you're trying to seek. There are two types of guardianships. There's the general guardianship, or plenary guardianship, as we call it, which is a full guardianship. And then there's a limited guardianship where you can actually limit the scope of what you have power over. And so this is a point of time where, Ashwini, I'm going to ask the audience to type in whether they think the statement is true or false. And the statement is, guardian of a person must always be different from the guardian of the property or the estate of the incapacitated individual. They're also called protected persons, by the way. So a guardian must always be different. Is that true or false? And Ashwini, if you can tell me, what is the majority of the response? Oh, and Ashwini, you're on mute.
We are seeing a lot of people say false.
Yeah. And so that actually is correct. You can have the same person serve in both roles. And so maybe my job is done. Maybe we should sign up. No, I'm kidding. So let's talk about who a guardian is, right? So the guardian is someone who's appointed by the court. This is a person who has authority over that person as well as their estate if they are being appointed as the guardian of the person and the estate. And this is of a person who has legally been declared as incapacitated. And so this is sort of important because a lot of people will think that if they have, let's say, a power of attorney in place, then they still might need to get a guardianship. But actually, a lot of times you'll have, a guardianship is a full-blown court-appointed process, whereas a power of attorney sometimes is referred to as the poor man's guardianship. Okay, and we'll talk later on about the differences between that. So who's an incapacitated person? I also mentioned that they're called protected persons now. These are people who are unable to govern themselves or to manage their affairs. And if you see that they could have some mental illness, they could have physical illness, and some of them could be mentally competent, but physically unable to manage their affairs. And of course, when you talk about before the guardianship, they're only alleged to be incapacitated, but the minute they're declared as incapacitated, then they're no longer an alleged incapacitated person, also referred to as an AIP. Now they become an IP, or an incapacitated person. And so next quiz, again, a true or false question. A person with intellectual or developmental disabilities may execute a power of attorney. And I get this a lot of questions when people ask me this. What do you think, audience, true or false? And Ashwini, again, if you unmute and just tell us what you see.
Again, I'm seeing a lot of false.
False. Very good. This audience is very smart. That is correct. In order to sign a power of attorney, you have to have capacity. And by the way, I'm surprised. I'm very impressed that everybody knows. The majority said false, because I've actually had a lot of calls where people call into our office and they've actually produced a power of attorney that the incapacitated person has signed. This person was deemed incapacitated since birth, and now magically they've got a power of attorney that the person has signed, and that is a complete no-no. So you cannot have someone who's got a mental incapacity, an intellectual disability, to sign a power of attorney. Now, having said that, someone who has capacity but is physically disabled obviously can sign a power of attorney. A power of attorney is like a contract, and so that is, you need a very high level of capacity for that. So a general or plenary guardianship is a full guardianship. And courts are always hesitant to give a full guardianship. And, I say this almost knowing what usually happens when an 18-year-old is now having his or her parents serving as guardians. But if you just stay with me here, the judges are a little hesitant, because what it happens with the guardianship is you're literally taking away all their rights. When you step into their shoes and act on their behalf, you can do pretty much anything and everything that the person could have done. And so courts are always a little bit apprehensive that they want to make sure that the right people are in charge. So that said, for all the people who have 18-year-olds and the parents have to now become guardians, we've had so many situations where the judges are so nice to the parents because they know how hard you've worked to be at this place. And it's like now they have to take these extra steps to sort of prove to the world that they are looking after the child's best interest. So it's a little bit of I would say that if it's an 18-year-old that you're applying for guardianship, just know that the judges are a lot more kinder, nicer, more approachable than if you are now in your 60s or 70s and you have somebody who needs to become a guardian. And now all, antennas are up because the judges want to make sure that nobody is trying to do this just to take all their money. So it's a very different situation when you're looking for a guardianship for an 18-year-old. That said, there are options for limited guardianships, which are more favorable. And this is really when you have people who may have capacity and can't just do certain things. I remember 3 or 4 appointments where the child, there was one child, we were applying for guardianship. The child loved to print. His purpose in life was to write something on the computer and print. And so he printed reams and reams of things. And we actually carved out a little sort of a limitation in the guardianship to say whoever becomes his guardian should allow him to be able to print as much as he wants, because this is what he liked to do. So these are ways that you can kind of put in certain freedoms and certain powers that would be put into the order. So whoever's serving as a guardian will be able to follow that and abide by that. So exercise independence as much as possible, as long as it's safe. This always happens in terms of, if they're able to do small things. We have a wonderful family in our town where the child has special needs, and she loves chopping using a chopper. And so the parent actually formed a nonprofit where now all the children with special needs come together, chop vegetables for people, and deliver it to homes. And so now that is something that could actually be carved out into the guardianship. So these things are what the petitioner of the petition for guardianship needs to be thinking about. What do they want to put in there? But that said, even the court-appointed attorney who then comes in to investigate, and we'll talk about that in a little bit, they also could put in certain provisions of what powers do we want to see in the guardianship order to limit the guardian's powers, where at least certain provisions are carved out for the incapacitated person. All right, so let's talk about the process. So we have a petition that is set forth. The petition is also called a verified complaint and an order to show cause. That's a typical motion that is filed with the court. In that, you have to submit a bunch of different forms. So if you're not registered with a DDD, or you're not about to receive any DDD benefits, you have a certain application, then you need 2 doctor certifications that say that this person's incapacitated and they're going to be incapacitated for the rest of their lives, or at least for the long term. And so you put the application in, you put the order in, and then you submit that, and then you get an order from the judge, which is signed with your hearing date. As well as in the order, there's a line which says, who's the court-appointed attorney? Now, this person's appointed by the court to go out and do an investigation. And now I have served personally as a court-appointed attorney on many, many different petitions. And it's more, again, for an 18-year-old who's just become an adult, the process is very enduring. You actually go there, you meet with the family, and you're just making sure that everything is fine, everything is safe. You check out the room where the child is that's his or her bedroom, making sure everything is good. There's no things that could be dangerous. And again, this is just a formality because we know as parents, everybody is all struggling to do the right thing. Then the report is filed, and the judges look at that report with a they give a lot of deference to that report. And then there's a hearing. Now, when we were doing this, I was telling Ashwini, we limited our guardianships last year, but when we were doing this, especially during the pandemic, a lot of the hearings were either conducted over Zoom or the judge just ruled on the papers. So it depends on the judge, it depends on the county, it depends on the backlog. But if it's usually very straightforward, then the judges will say, we'll just rule on the papers. Sometimes they'll just say, let's just do a quick informal hearing. I used to do a lot of hearings where Judge Jacobson at the Mercer County Court would actually walk down from the podium and come and visit the family and hug the child. And, so like I said, it was a very amicable sort of process. It can get messy depending on, who and when and what, but for the most part, it is a pretty informal hearing. And then once the petition is granted, now that it's not, it's not over, you have to still go and qualify. So this is how a case information statement looks like. I'm just going to show you some of the legal documents. Here, this is not a public document, so you have to put some social security numbers in there. You also have to put who are the people here who might be interested parties. And that's really important because if you have family members, if you have, let's say, grandparents who are applying for this guardianship, and now the other set of grandparents of the other parent has to be noticed, those are all people who would have to get noticed. And so you would want to put all of the people down in this case information statement. And some confidential information is put in there because this is not a public document. But then when you file the verified complaint, this is actually a public document. And here, of course, I've put at the verified complaint that is for DDD applicants. Now, this one is a special form that you would use just for those who are in DDD or about to get DDD services. But here, it's really the complaint says who you are, why you're petitioning for this guardianship, and give some important details. And then lastly, this is how the certification of the physician looks like. This is different from other competency forms. This is very, very much what you would need to use with your application. And here the physician actually fills this out and kind of describes what the condition is and why they think that the person is incapacitated and why they need a guardian. Psychologists could be a good substitute. A licensed psychologist would be a good substitute instead of a physician. Sometimes physicians are hard to get. And we've sometimes had licensed psychologists actually come to our office and do an evaluation and fill out this report. This is an important part for people who are worried about the expense. There is a way to actually get the court-appointed attorney. Now, the court-appointed attorney services are not free. It's usually a paid, it's a paid arrangement, and you pay from, usually the parents end up paying for this court-appointed attorney. There is a way to access free assistance, and this is by calling the Office of the Public Defender. Now, the only problem with that is you have to wait because it's free, there's a lot more of a wait list that you have to get on. And so sometimes parents will find it just easier to just hire somebody and pay the court-appointed attorney, and say you'll be paying the attorney who brings forth the petition, and you'll also have to pay the court-appointed attorney. Once you qualify, you have to do this within 30 days. And now here you have to sign some paperwork, get some training under your belt. You have to do a background check. All of this is, again, very, very, very important when it's somebody with assets. Even the bond posting, now there's no estate for the 18-year-old, there's no bond that you're going to be seeking. There will be a carve out in the order that says if and when the child does come into money, then you will have to come back and amend the order to get a bond posted. But you will have to periodically file some reports, and you'll have to do some accounting again if there's an estate. Okay, so some dues. The guardian really has to exercise some discretion in how to manage the person's care. There is a substituted judgment and the best interest judgment, and all of these are just to say that if you knew what the person would like, you need to try and do it as much as possible according to that person's desire. But obviously, if they want to cook and fire is a hazard, then you have to apply the best interest test. So if that's not in their best interest, you have to consider that, and you have to say nope. They can't do so and so. Now you do have to, as a guardian, you're responsible for their health, education, and welfare. You need to be making medical decisions on their behalf. And so this is where having a guardianship in place is really helpful, because you can just say, I'm appointed as the person's guardian, and because they were incapacitated, they couldn't sign a healthcare power of attorney. So therefore, this order will allow you to talk to the doctors, etc. So again, parents who have been doing this all your life, this may seem strange that now you have to go and get formally authorized to do that, but that's unfortunately the law, because once they turn 18, they become adults under the eyes of the law. And now you've got the other part of this, which may not be so applicable to those who are 18 turning, who are just turning 18. This is more for people who have gone beyond the age of 18, have run out of money, they need SSI or some Medicaid benefits, and so now you could actually put it into the order that you need to file for their Medicaid. So that's something that the court will allow you to do. You need to file periodic reports of well-being, again, inform them of any changes. If you move across state lines, you have to inform the court and say that there's going to be an address change. By the way, this was actually quite important for us. We came across this with one family where they were moving their mom from New Jersey to Seattle, and they had to reinstate the guardianship there. That process took a long time, and in the meantime, she unfortunately passed away. And later on, I'll just give you a suggestion of what I think is a good idea to do to counter this problem. Guardian don'ts. Don't pay yourself until you're authorized. There is a reasonable compensation that you can get. Again, I'm talking about maybe non-parents who are guardians, or maybe siblings or other people who offer to become guardians of the person. You have to really get that. There is some statutory right, but you have to be careful about how much you take out of there. And then you can't commingle your funds. You can't take the guardian's money and put it in your bank account and vice versa. So you have to be careful about that. You can't make gifts without court approval, and you can't delegate duties without the consent of the court. So keeping all of those in mind, you just really need to carve that out into the order. Ashwini, we're ready for our next question, our quiz. A guardian may not execute the will of an incapacitated individual. That means, can a guardian sign a will, execute a will for the incapacitated person? And this is saying may not. Is that true or false? I should have numbered these questions, Ashwini, so that it doesn't overlap with the previous answers.
It's fine. I'm getting there's mixed responses, true and false. Both are so this is
okay. So I caught you guys in at least one place, because right now they were already two for two. So the answer is actually true. They cannot, and maybe I threw in a double negative, so that's why or a negative, I should say, that they didn't get the answer right away. But you cannot sign a will. That's the only thing you cannot do. You have all the powers in the world, but you cannot sign a will for the person. So that is a misconception that people have, that they think that, okay, they can redesign the structure of what happens to their assets, especially if there's like a special needs trust, etc. But they cannot do a will. One tip. So this is the tip that I was going to talk about for parents. I said aging parents, but anybody who thinks it may be beneficial to have a co-guardian with a sibling, or that means another child of that parent, or the sibling of the incapacitated person, it may not be a bad idea to bring an amendment to the guardianship application where you say, I want somebody to be appointed as the successor, and do it when the parent is competent, not aging, and has the ability to, aging is relative, right? If they think that, I had an elderly couple maybe in their late 60s, early 70s, who said, they were worried about what was going to happen down the road. And so we brought forth a petition to the court to say, can we add the brother of this incapacitated individual? And that was really nice, because when that happened, now if something happens to the parents, the brother steps in. Now, in the other case, what happened was, by the time they moved to Seattle, and by the time they were trying to establish a court there, and now state laws came into play, what happens in Washington State is very different than what happens in New Jersey. And so when all of that was getting aligned, unfortunately, the mother passed away, and it was very traumatic for the son, who was trying to become a guardian of his special needs sister. So that was the scenario there. So it's not a bad idea to start thinking along those lines. It may be hard to establish co-guardianship of a sibling right away, when the sibling, like let's say let's say your child says just turned 18, you're a young couple, maybe let's say in your 40s. If you have another child who's 22 or 23, maybe a little bit more hard pressed to get the court to say the 22-year-old should also be a co-guardian. It all depends on the situation. If you have a good reason why you want that, that might be okay. But I think just keep thinking about amending the guardianship application down the road as a better way to do this. I've put here a link. I know, Ashwini, you said that the slides are going to be shared with the audience, but there's a lot of good information on the court's website that can kind of guide you through this. That said, I think it is also intimidating a process. So it's always better to get an attorney to help you because we sort of do this day in and day out. All right, one more question for the audience. Now here, you have to type in A, B, C, or D. In terms of annual accountings, do you, as the guardian, must you file only if the guardian is not a parent? Must you file the accounting only if the guardian is bonded? Must you file the accounting only if the guardian is asked to do so in the order? Or D, none of the above, a court-appointed guardian must always file an annual accounting with the court. So Ashwini, if you can unmute and tell us what people picked.
People are picking D.
D, oh, interesting. Yeah, no, the answer is actually C. The guardian does not have to file an accounting just because they're a guardian. There's many other factors, because remember what we said, guardian of the estate, that's when you have to get bonded. If there's money, then you have to file an accounting. So unless the order actually demands that, you don't have to file an accounting. And a lot of times with children who have just turned 18 and their parents are becoming guardians, there's no estate, as we mentioned before, but there will be a carve out in the order that says, if the child ever comes into any money down the road, you have to come back and get the guardianship application, the guardianship amended to include a bond. So, and then at that point, you'll do the filings. All right, some best practices. These are, and by the way, I didn't mention this before, but I'm really, really proud to have just been selected as a sponsored member of the Special Needs Alliance. And why I bring that up here is because I've now got access to a robust list of attorneys who are all across the country who are actually doing some really good work in the space. And so this listserv is a wealth of information for all of us who are planning with special needs or in this area of law, because we've got people to, run off ideas and see how people are doing things. And so I've just become a member, and I'm really excited that, with this opportunity that you've given me, Ashwini, and the SKN Foundation has given, I think I'm looking forward to, sharing that knowledge down the road as and when it's needed for your members. But one of the things that's very, very important is filing for the SSI. And that is tied to the whole Medicaid, the Medicaid benefits. And if you do this before the child turns, and we say 18, but if they can do it before 22, there's a lot of formula that goes into the benefits, where if you file at a certain age, then if the parents then retire, then the child can maximize what's coming into their names. But if you wait and you try to apply for SSI later on, you may get kicked off. Those details are now part of the scope of this presentation. But I just want to say, if you can take away something, it's just that go ahead and just make sure that you can file for SSI at least at the age of 18, and maybe if not soon after. This I strongly urge everybody to do. There was a question in one of the survey questions, Ashwini, that we circulated, where someone had said they wanted to know more information about a standalone trust. Now, and I think before the webinar began, we were also talking about parents who are worried about if they have two children and one has special needs and the other doesn't. How do you prepare your plan in such a way that you're fair to both the kids, and you also, in one case, maybe wanting to take care of your special needs child more than the other child who can go and get gainfully employed? So a standalone third-party trust, and I say third-party, and we'll talk about it, Ashwini, I think you'll announce later on about the trust webinar that I gave before. But the standalone third-party special needs trust is really, really, really important for parents to put the parents' money in there, including maybe life insurance when they're gone, but also grandparents, nieces, nephews, uncles, aunts, anybody who wants to give money to this child can use the standalone third-party trust. And I want you to remember the word third party because it's very different from a first-party trust, also known as a D4A trust. Again, not the scope of this presentation, but just if you all can think about setting up third-party trusts, if you know that there are other people who want to give something in their wills to your child, then their wills can name the special needs the trust for your child in their wills. So that's a good way to do this. And the best part about this is it's not recoverable by the government when the child dies. So that's the beauty of the third-party trust. So keep that in mind. Set up ABLE accounts for those of you who've got children who have been diagnosed as developmentally disabled prior to the age of 26, which most of you have. Then set up the ABLE account now because that actually gets them a lot of benefits to be able to use that money very without too many restrictions that a special needs trust has. Get life insurance. I love life insurance to have to name the beneficiary as a special needs trust. That is a really good way to get money into your child's name so that they can be taken care of when you're gone. Get your own estate plan done. Please do not leave it to the laws of intestacy where New Jersey decides how money should flow and then inadvertently knocking off your child off of Medicaid benefits. So that's really important. This one is an important one because, and maybe all of you already have been registered as representative payees of your child's Social Security benefits, but Social Security Administration is the one place that does not accept a legal financial power of attorney or a general durable power of attorney. You have to go and become a rep payee. So be careful that you just go ahead and become a rep payee and do it as quickly as allowed. And then I bring up this life care plan only because I know that this is something that has been on my mind as well for a long time to see how we can better serve our clients. We don't offer a life care plan, but I know that other firms and other organizations do. And it's a way to make sure that whatever you're doing now for your child, you will make sure that you can do after you're gone. And there's a bunch of nurses and social workers who are all kind of involved in the child's plan. So I think that is quite beneficial. Okay, so I'm at the end of my presentation, and I would like to know if anybody understood the significance of that video that I showed earlier. I don't, because I can't see you all, and because it's not a true false answer. I think I'm going to just share the answer that I'm hoping that you all got. And that is the last line of that blanket video said, "It's better to have it and not need it than to need it and not have it." And so get your peace of mind today. And I think if you think about estate planning and setting up, doing all of these things that would be important to your loved ones and to create as smooth a journey when you are gone or when you're incapacitated, I think I liken our estate planning world to be like a fire blanket. So with that, I am going to open it up to questions. I know we have about 15 minutes, Ashwini. So I'm going to stop share and see if anybody has questions.
Before we get to the question, a lot of our parents just sent you their congratulations on being part of the Special Needs Alliance. So just wanted you to know that.
Oh, thank you.
We do have some questions that was asked earlier let me get to that part and then we can have people unmute and ask the other question. But there was one question right at the beginning which said something about the court, which court it was.
Courts appoint, which court? Surrogate's court or the county clerk? Yeah. It's the surrogate court.
Mm-hmm.
That's the court that appoints the entire proceeding is done in the surrogate's court. And so that's who will appoint your one. And then you'll go into chancery court to actually, it's a probate part where you actually get appointed. But the surrogate is where you'll get qualified, you'll get your letters of guardianship, etc.
There was another question. Can one select you, as in you, Rekha, as a court-appointed lawyer?
No, actually, the court appoints one.
Okay.
So what happens is the court has a list, and that they kind of go through that list when they have these cases. We have been appointed by the court on many an occasion to be a court-appointed attorney. But so people can't choose the court-appointed attorney. The court will have to select one.
Okay. Okay, so someone is asking, yeah, so about the fire blanket, most of them got it. Yeah, COVID taught us a lot. Okay, that's true. Okay, how do we find out more? One second, more
About a life care plan.
Mhm.
I'm seeing that. All I can say right now is we're exploring different options ourselves. I know some law firms have offered that as part of their service. There was up until very recently, there was a company called Hope Trust that was actually doing this, and I was actually sending a lot of my clients to them. Where this gentleman who started this, his brother had special needs himself, and so he started this where he had created this life care plan for anybody who would sign up with their for their services. Unfortunately, the last I heard is that he had to close it down, and I don't know for what reason, but I am keeping my eyes and ears out. Stay tuned. If I can get some information on this through my SNA Alliance now, like if I can get more information for the New Jersey folks, I will definitely share that with you through Ashwini.
Sure. Do you or office help with the DDD and SSI application process?
No, unfortunately, we don't. We are more into the special needs trusts and setting up trusts for the clients, but we can guide you through. Usually, the schools are very good in helping with at least giving information as to where to go, and a lot of the stuff can be done directly by you guys. But that said, we do not do that.
Is guardianship needed for 18 plus kids, 18-year-old and over, and families who are only on visa here and for a few years?
That is a really good question. And I think it's Ashu that you've asked that question. I will say that from a Medicaid standpoint, because we help the elderly get onto Medicaid, our office does that a lot. We know that you have to be a green card holder for 5 years before you can apply for that type of Medicaid, which is the MLTSS program. But for a child who is here, who has disabilities, I'm not 100% sure of whether they have the same time constraint. So if you could just email me, and I'll share my last slide at the end with the contact information, I will try to get that information for you.
Any tips about kids getting into college? I think that is out of the scope of this workshop. Do we get SSI benefits regardless of
household incomes?
Yeah.
Yeah. So remember, when your child turns 18, the child's income is what is looked at, right? So you need to get SSI for the child who is now an adult. There are different reductions and deductions based on what the family is providing in terms of income. But for the purposes of SSI, you just want to get them registered, and whatever they get, they give you, because that's tied to the Medicaid benefits program. So yes, go ahead and get them onto SSI, and then they will tell you how much the child can get.
if we get guardianship for a child, are they allowed to drive if they can, or does guardianship automatically takes away all that right?
And that's a really good question because, see, right there, I would say that that's a limited guardianship because there's no need to do a plenary guardianship for this one, right? Where you can say, my child can do X, Y, and Z. I don't want a full-blown guardianship that is going to take away those rights. I still want to keep those rights for him or her. So I think that that would be a good limited guardianship type of petition.
And next one, adult medical daycare. Okay, this is okay. Sorry about Kshitija. Are you running the poll?
I think there's one which is saying there's a company called NetLaw who offers special needs trusts. Do we need to do it with an attorney or can it be done with the NetLaw? This, if I may, I would love to make a statement for attorneys and the specialty attorneys who do what we do. Really worry that when you go and do something with a company like LegalZoom, NetLaw, some of these online trust and estates type of companies, it's the one thing I would like people to know is none of this stuff is boilerplate. Everything is tailored to your specific provision. So if you go to these companies, they're giving you what is sometimes national. And so I worry that you're not looking at state law. You don't have access to an attorney who is a specialized attorney here. There have been times that people who are real estate attorneys who are drafting powers of attorney come to somebody like us and we were like, wait, we don't have the powers that we need to get you onto Medicaid. So it's really, really important to have the right attorney help you because we're not just looking at forms. If I were to give you a document that's just saying here, I put your cut and pasted your name and put it here, and this is the document, that would be malpractice on my part. So there's a reason why we're here. That's why we do that we specialize in these areas. And I would caution you to be careful about going to just a form that's treating you like a number and just be careful.
Okay, so
I think the one I see next, there's actually somebody who's commented on the fact that child must be a citizen or green card holder for 5 years. So I don't know, Anil, if that's right, because of the fact that this is a different type of benefit that we're availing ourselves of. So I need to do more research to get that information.
right.
But Shadija, you asked the question, when exactly do you apply for guardianship? When the child turns 18, or can we do it before? And the answer is some courts will actually allow you to do it a few months before the child turns 18, where you can start the paperwork. And obviously, once the order is granted and circulated, it'll be after the child turns 18.
Does your office help with Medicaid application for 26-year-old?
So far, no. We've always been helping the elderly, but it shouldn't be too difficult to help with the younger adults as well, because of the fact that it's pretty much along the same lines with some twists and turns. And so we can definitely explore that and see. We haven't, so in all candor, we haven't done one yet, but we are open to looking into that if needed.
Okay, so someone is asking what is ABLE account. I think it is addressed in our special needs workshop, which was done.
Yeah, that is actually nothing more than a bank account, but it has opened up the lives of a lot of the special needs individuals because you can actually if your child is capable of managing money, you can get them a debit card and use this to pull out money before we used to have a problem with food, clothing, and shelter to be used from a special needs trust. Now, of course, they're loosening up the rules against that. But from an ABLE account, there's no real supervision per se, that they're not so harsh. So it's a good way to put at least $100,000 aside for a child's needs through this ABLE account where they can access it for their needs.
What the cost, best guess, if I go through your firm to get special needs trust and guardianship?
Yeah, the guardianship is a little bit more tricky because that could run into an hourly type of billing. The special needs trust is very straight. Like for us, it's always going to be a $69.50 fee. It is a lot, but it is one of those things that, again, depends on what kind of trust and how. So we'll have to talk about that. But you would be looking at a few several thousands to be able to do something like this, both from a guardianship standpoint and from a special needs trust. The only thing I would say is with the guardianship, just be careful that you have to have somebody to help you with the petition. But remember that extra fee with the court-appointed attorney that the court actually will make you, again, sometimes it could be pro bono, but sometimes you have to pay. So the cost could add up for a guardianship.
I have group legal plan from my company. Do RLG accept it for preparing trust or will?
So it depends on the type of plan. We don't participate in any of those plans, but there's MetLife in particular that comes to mind, where MetLife does a reimbursement. So if you are part of a MetLife plan, we can bill you our rates, and then we give you a certain type of invoice, which is a breakdown. It's a little bit more of a detailed invoice, and you take it to your HR, and then they will compensate you or reimburse you for a portion of that.
When can we set up the ABLE account, before or after 18 years?
It has to be after. And it has to be somebody who's already on Medicaid. So keep that in mind. You can't just do it because you have to prove disability and, there's other things, but you want to be able to, this is really for people who are on Medicaid who cannot have more than $2,000 in their name. The ABLE account is like a substitute special needs trust, but with less restrictions and a limited amount. You can only do 100,000.
Okay.
I see a question which says, when can we, oh, this was the one you just read out, the ABLE account. Okay.
Where can this ABLE account be set up? Bank?
Yeah, usually banks.
Okay. And
thank you guys.
Everyone, please participate in our poll too. It will help us. If you can share your thoughts, feedback, and while you guys do that, thank you so much, Rekha, for such an awesome presentation. You shared so much information. As always, I'm not surprised. You always bring your expertise and you share it in a way that is understandable for us. So thank you so much for taking the time, for all the the extra information you asked for to prepare the slides more for our family. That was really nice of you. Thank you so much. And thank you all the participants for joining on the call and sharing your question. That was awesome. Yeah, thanks everybody.
Absolutely, my pleasure. You guys are doing a really good service to the community. So always happy to come and speak whenever you need me to.
Yes, we will definitely want you to come back again. I think special needs trust is a hot topic. Though you did it before, but maybe you can add more nuances to it, and we would love that.
Yeah, there's been some small changes in the law, so I'm happy to come back and speak on that. Yeah. Thank you, everybody. This was really nice to see such a big audience. Usually I have like 3 or 4 people in my office come to listen to me, so I'm really glad, Scan, that you've got this robust group.
Yeah. Thank you so much. All right. Thank you, everybody, for joining the call, and good night.
Good night.
The mission of SCOPE is to support South Asian families of children with special needs through activities that educate, advocate, and empower. For more resources and upcoming sessions, subscribe and follow SCOPE.